America, country of life, liberty, and the pursuit of lawsuits? Yes, Speaker Boehner is suing the president, and the House Rules Committee just held a hearing right now to consider that suit. If they approve, the full House will vote on whether or not to sue. The legal question is this: did President Obama's reliance on executive orders overreach his constitutional duty to faithfully execute the law? The lawsuit is hanging that question, somewhat ironically, on the decision to delay Obamacare's mandate that employers provide health care insurance starting in 2014. Yes, you have that straight. House Republicans suing the president for undercutting the very law that they fought tooth and nail. Here's what Committee Chairman Pete Sessions said this morning.
The president, in my opinion, has gone too far. Rather than faithfully execute the laws as the Constitution requires, the president has instead selectively enforced the law in some instances, ignoring the law in other instances, and in a few cases changed the law altogether, all without going through the required constitutional lawmaking exercise.
Neither the House nor the Senate has ever sued the president as an institution. Can this case make history? Here for a little legal analysis, California Congressman Adam Schiff, who is also a Harvard Law alum and a former federal prosecutor for the U.S. Attorney's Office. Thank you so much for coming, sir. Always a pleasure to have you on. Article 1 of the Constitution, of course, gives the power to legislate to Congress, and Article 2 says the president needs to, quote, faithfully execute those laws. Is delaying the employer mandate really unfaithful?
No, it isn't. And, of course, this is something that presidents have done throughout history. And, in fact, George Bush did in terms of the smooth implementation of that Medicare Part D, the prescription drug benefit. So presidents do it all the time. But in addition to the fact that this is nothing new or extraordinary, the only thing that would be extraordinary here is the idea that one House of Congress can sue the president over a policy disagreement. That really would be unprecedented, and I think plainly the courts are not going to permit it. There's no legal standing here for one House of the Congress to complain, particularly when there's another remedy, and the remedy would be if Congress doesn't like it, Congress can step in with another law that explicitly directs the president to do something or cuts off funding to do something. So there are legislative remedies here that there's no way the court, I think, is going to step into this mess.
So in your view, what is an overreach of executive power in legal terms?
Well, if there was an explicit statutory mandate that the president do something, or that if the president violated, say, the War Powers Act, there might be an institutional injury that we could show legal standing to bring suit. Even then, it would be hard if there's still a remedy for the Congress to take. If Congress acts explicitly to direct the president willfully ignores that, there may be a case there, but even then, it would be hard in the absence of a showing that there's no other way for Congress to respond. Here, Congress can take the action of not confirming any of the president's appointees. Congress can take the action of explicitly defunding things that the president wants to fund. So there are lots of remedies here. But one, I think, far-reaching consequence here is if this court were to allow this to go forward, it would be exactly what conservative jurists and conservative commentators don't want to, and that is it would empower the court to become an activist body and basically decide policy-making decisions, which is not something that conservatives want, and certainly not something that I think Constitution scholars think is appropriate.
And that's exactly why typically courts do decline to hear suits of this type by members of Congress for lack of standing. You mentioned that's the basic bar to getting into court on an issue. You got to show an injury in fact, you got to show causation, and you got to show a way to redress it, which you mentioned. The lawyers behind this particular suit are saying that there's a precedent for granting standing in this case. They're citing this case, Raines v. Byrd from 1977, and saying that was a case where legislators whose decisions had been nullified by executive action were found to have been harmed by it and were allowed to bring suit because of it. Is this case different from that?
Well, it is different than that. And I think if you look at the legal reasoning in that case, several of the justices expressed a great skepticism about the idea that one House of Congress or even both Houses of Congress could simply jump into court, pop into court, I think in the view of one of the justices in that case, whenever they wanted the court to referee a policy difference. There are, exceptional circumstances, and for example, when Congress's subpoena power has been undermined, when there is a need for the Congress to continue with the performance of his duties where the court has found a legal injury. But those situations are very rare. What the courts have said is that when the court is done with its business, which is legislating, and it becomes an executive matter of implementation, the House and Senate no longer have legal standing. They may feel an injury. I mean, I feel an injury when laws that I've authored maybe aren't implemented the way that I would want, but that's not the same as a legally recognizable injury. And the difference between the two is very sound, because in the absence of distinguishing policy injury or a perceived injury from an actual legal case or controversy, we prevent the court from becoming the arbiter of policy differences, which would be very destructive to our form of government.
And look, Congressman, aside from these very real legal problems, there is, I think, a kernel of an underlying point in Congress rising up and saying the balance of executive and congressional power maybe isn't what it should be. There was actually a constitutional lawyer, Jonathan Turley, testifying at that hearing we mentioned today. Take a listen to him on this.
When a president can govern alone, he can become a government unto himself, which is precisely the danger the framers sought to avoid. What we're witnessing today is one of the greatest crises that I expect the members of this committee and this body will face. It has a patina of politics that is hard to penetrate. It did not start with President Obama. I was critical of his predecessor, and certainly this goes back long before George Bush. But it has reached a tipping point.
Sir, is the balance of power between Congress and the presidency what it should be right now?
Well, I think there are sound arguments to be made that that in fact we've seen a great accretion of power in the hands of the presidency at the expense of Congress. But it's not because of actions like this, where we have delayed the implementation of an employer mandate to allow for the smooth implementation of the broader bill. Rather, it's a function of the fact that Congress is so dysfunctional, Congress is failing to do its job and failing to act, and the executive has had to rely more on its executive power. So it's really hard for the Congress to complain here about the growth of executive branch authority when we have the remedy at our disposal, which is to do something. And indeed, in the context of the Affordable Care Act, the remedy here, if the Congress doesn't like what the executive is doing, is to pass a bill that says that either repeals discretion under the taxing authority or says that it must go into effect as of a certain date. But, of course, the Republicans don't want to do that because they don't want the employer mandate to go into effect at all. Only in Washington do you have a situation where House GOP is ready to sue to implement a law they don't like.
And you make the fundamental point there very loudly and clearly. Doing something is an answer that Congress just seems unwilling to turn to. Congressman Adam Schiff, really appreciate it.
You bet.
And